Okay. We are being streamed live on the web with regard to both audio and video. Mr. Reilly, if you're ready to proceed, we'd be happy to hear your arguments.
Thank you, and good afternoon. It's a pleasure to be back before you again in this matter.
Well, I have a question.
Yes.
Start out with, if the court, the appellees are relying on the provision in the court's original findings and conclusions to the effect that the association cannot assess, I'll refer to them as the innocent unit owners, and the court dismissed your claim based upon that provision, and you're challenging the court's authority to do that, the court's reasoning. If the court wanted to enforce that provision of the judgment and limit your ability to collect from the association in that manner, how should the court have done it?
If the underlying court wished to limit my ability to collect from the association by not allowing the association to assess, is that the
Right.
question? Okay. Well, in the first instance, again, obviously that's not the direct question that's up here on appeal. We're dealing with the statutory lien provision, which is a separate provision from the assessment provision in the main Condominium Act. But to answer your question directly, I don't think the court has the authority to prohibit a condo association from assessing unit owners for a judgment against the association. An association, a condominium association, is comprised of unit owners.
But the court did that here.
The court did do that.
And you've not sought relief from that judgment. That is indeed the judgment that's being enforced.
That is correct. That is not the basis for our appeal.
We understand that's not the basis for your appeal, but you started off by saying that they didn't have that the court didn't have authority to do that. But isn't that a moot point at this point? That is in fact what was done, and that hasn't been challenged.
I agree. That is not an argument we're making on appeal. It is an entirely separate issue from the statutory lien process that's at play here.
Can I ask you, I follow up, and let's go a little bit off topic here, but on the November 3rd order granting the remaining 12B6 motion to dismiss, just reading through that, I mean, we're trying to decide to what degree the judge below wanted to inhibit or prevent your ability to collect the judgment. And he says this is at appendix page 5, and the court seems to be trying to explain itself without making express findings. First, the underlying judgment does not provide for a kind of judgment for money against the association that triggers Title 33, 1603. The underlying judgment contains an express provision protecting the non-party unit owners from becoming the source of payment to the plaintiff's judgment against the declarant and association. Although the underlying judgment speaks in terms of prohibiting a special assessment, the intent of the underlying judgment is clear: to restrict liability for payment to the declarant and the association, and to shield the non-party unit owners from judgment. As a consequence, the underlying judgment is a limited or restricted money judgment and cannot serve as a judgment lien on the non-party units of the condominium pursuant to Title 33. What do you make of that?
Sure. Thank you. And as we said in our briefing, the judge was reading a number of provisions into the statutory lien provision that do not exist.
Was he reading it into the statutory lien provision, or is he saying, regardless of that, this is what I intended by the judgment?
But the underlying judgment must conform to the statute. The statute doesn't need to conform to the underlying judgment. And this is a separate issue from the assessment issue that we were just discussing a moment ago.
Right.
In terms of the statutory provision, that all the statute requires is that there be a judgment for money and that judgment be properly recorded.
But could the judge simply say, yep, there is a statute that says this, but I'm saying, no, you cannot proceed under this statute?
In
No.
this case, not as
No.
a general proposition.
No, because there is a statute that is available as an enforcement mechanism to us. That the judge cannot write that statute out of existence as to us or as to anyone else. That statute exists. There is no qualification as to the type or restricted nature of a money judgment. There is a judgment for money against the association, and it was recorded properly.
What if in the underlying judgment he had explicitly said, X judgment against the association with the proviso that it cannot, not only can it not be assessed, but it cannot essentially be enforced in any other way by means of judgment lien pursuant to this statute or anything else against the individual unit owners? If he had said that.
So let me answer your question, but first let me just say one thing before I answer your question, is what we would be creating in that instance. Again, this is a case that involves a judgment against a condominium association. It is specific to the Maine Condominium Act. That is a different animal than many other judgments. A condominium association exists solely as a group of unit owners. A judgment against an association that is not ultimately collectible or enforceable against the individual unit owners in the association is a useless and unenforceable judgment, period. So for the court down below to have said, I'm going to give you a judgment, and then in the next breath make it absolutely unenforceable, because to be clear, the association can only pay a judgment against it if it gets money from a source. And that source that it can get it from are the unit owners. That's it. It could borrow money, but the pledge and security to borrow the money from a bank is going to be the assessments or other stuff or the monies that it gets from the unit owners.
But the court is kind of explicit about what it's trying to do here. It says, in other words, plaintiffs are in part seeking to enforce a judgment of a lien against themselves. Courts should avoid interpreting a statute in a manner that leads to absurd or illogical results. So you got innocent people who actually suffered the same thing the judgment is for, and he's trying to backdoor the fact that he doesn't want to have these people in the line of fire.
He says a couple things in that passage you just said. First, that my clients as unit owners somehow are precluded from bringing a claim against the association in which they are members of. We addressed that in our briefing. First off, nothing in the statute says that. Secondly, our jurisprudence here in Maine are absolutely full of examples of unit owners and associations bringing claims against the association, even though that unit owner, by default and by necessity, has a X percentage of that responsibility of the judgment against the association. Were that to be the law, there could be no case in which a unit owner brought a claim against an association. It would be precluded by that. There is no Maine authority that says that, and certainly the Maine Condominium Act doesn't say that. The second piece that he said in there is that, well, because there are innocent unit owners.
Right.
There is no such thing as an innocent unit owner. I don't mean pejoratively.
I know.
But there is no such thing as an innocent unit owner in a condominium association. That shows a misunderstanding of the condominium association. Anybody that buys into a condominium association as a unit owner knows that they are responsible for assessments. They are responsible for judgments against the association. That is the nature of the beast. There is no carve-out or exception to that.
So is there anything in the Condominium Act that precludes your client from actually having bearing a proportionate share of the lien being imposed against?
No. No, we are responsible for our proportionate share of the judgment.
So you're saying that while the trial judge is saying this is unfair, what the judge is complaining about is the statute. And if the statute's unfair, bring it up with the legislature. He can't rewrite the statute.
That is correct. And in fact, I would argue it's further not unfair and further no innocence. And again, I don't mean this pejoratively. But in this specific case, the unit owner that owns all of the units bought all of the units after we had obtained the judgment in this underlying judgment and with full knowledge of the judgment. And one can assume that factored into the purchase price for those units. So while we might have some fairness concern on an ongoing basis in general about other unit owners, although, again, if you're concerned about that, don't buy a condominium unit.
So the units owned, but was it the Orno group?
That's correct.
So they would be tagged for this judgment.
And to be clear, and I haven't done them, I'm not going to do the math here in front of you right now, but there are 24 units, 15 are exempt from this because of the foreclosure action that happened previously. And that wiped us out as to those 15. That leaves 9. Of the 9, 2 are my clients. So we're talking 7. There are 7 unit owners at play who bear their proportionate share under the statutory lien. That's what we're talking about.
So at this point, the attorney fees might be the tail wagging the dog or vice versa. So do you have anything to add about whether fees are included in the amount that you're able to get under the statute?
Yes, and again, as I've mentioned in the briefing, I don't think that's actually been challenged on appeal, but they clearly were. Again, the statutory language speaks of judgment. It doesn't speak of money damages or legal fees. It speaks entirely of judgment. And what was clear is that the underlying judgment that was entered in this case, the attorney's fees were awarded under several different claims, which were against both the LLC and the association, and there was no division by the court, and quite frankly, not really one that we could do because the claims are the claims against. There were attorney's fees awarded as part of the judgment against the association.
Is it your position, counsel, that those 7 remaining unit owners are responsible for 1/7 or 1/20?
1/24th, Your Honor.
So just to make sure I understand what you're really saying for math, if the judgment were $240,000, I know it's not, but if it were, with 24 units, 15 being exempt, 2 being your client, that leaves only 7. Essentially, you're saying I can only collect $70,000.
Yeah, the most that we can collect at this point under the statutory lien process is 7/24
Okay.
of the amount of the judgment. That is what we can claim because obviously I'm not counting ourselves for our 2
Right.
units, and we're not counting the 15 that our
So
lien
you're not
was
saying
wiped out
that
on.
because
under
of the
foreclosure.
exemption, it all falls on the others. You're saying each one is only
That is
responsible
correct.
for their original.
That is correct. Yes.
Well, are you saying that the judgment lien can include post-judgment attorney's fees? In other words, your collection costs on the judgment?
Yes, Your Honor, we are saying that because to go back.
They're not part of the judgment.
They're not part of the underlying judgment, but they are part of the cost of collecting the judgment, which under the Maine Condominium Act we are entitled to recover, would be our argument.
Thank you.
Thank you.
Despite the fact that we've heard the argument before, we still managed to ask plenty of questions.
Always a pleasure.
Good afternoon, Your Honors, and may it please the Court, it's nice to be back here again. Whether or not the trial court had the power to restrict or affect the statute's already been determined in the underlying judgment. The assessment is by statute, 1603-115. The judgment lien statute is 1603-117. The trial court already restricted and modified a statute, and it was before you, and you affirmed the judgment. I think that issue's done. I believe that the equitable power of the court is extremely broad, and it's allowed to even limit and exclude pieces of the statute. I would refer you to the Dickout versus Vermont Mutual case, which specifically talked about ways to avoid abnormal and illogical and unreasonable results, even including to read exclusion into a statute when to do otherwise would render it at odds with the justice of the matter. So in this case, we have the possibility, rather the fact that the judge had the power, and it's already been affirmed that this judge had the power to affect the condo assessment statute.
Well, counsel,
How is this different?
there's a difference between construing the statute, which was the issue in Dickout, and overriding the statute, which I understand the plaintiffs are maintaining here. And isn't it a time-worn maxim that equity follows the law? And if
Yes,
there
but-
is a statute in place, the court doesn't have the equitable power to set that aside.
No, but it has the equitable power to limit the application, because I believe the judgment lien follows the judgment. And if the judgment itself has been limited and restricted, and the power to do that is equitable, and the court has that power. And if the court says these people should not have to pay this judgment, then I believe the court has the power to limit the judgment so that the judgment lien statute should not be mechanically applied. It would end up with an absurd result. So the other question is anything in the orders on appeal, which is not the underlying judgment, it's the the motions to dismiss orders, they are not ambiguous. And they must be enforced according to their terms. And there's nothing in the law that requires the mechanical application of the judgment lien statute
But
on
this
these
is-
unique facts.
But this is before us on a motion to dismiss, right?
Yes.
So, I mean, there's no question that ordinarily, but do you agree that but for the judgment in this case, that this would be an appropriate use of the statute? But for the judgment. In other words, if the plaintiffs had a judgment against a condominium association, this is an appropriate means of collecting that judgment, in general.
Yes, it is, but in general,
I understand, but for the judgment here, in other words.
I think in general, without getting into the specifics, that's how the system works. But the unique facts of
And you're
this
saying
case-
that the judgment here limits that ability to do that.
Yes.
So, but isn't then, are we really beyond a motion to dismiss? I mean, isn't what's happening here, then the judge essentially, and maybe he can, maybe he can't, but essentially interpreting and rewriting the judgment to make clear that this is a tool that is not available? Can he do that on a motion to dismiss?
I don't think he's interpreting or rewriting it. I believe that at the time the initial underlying judgment was issued, no one, including the appellants, had any intention of having to enforce it against unit owners. They assumed they'd enforce it against the 15 units owned by the LLC. And in that case, the LLC, there should have been a judgment lien against the LLC's units, but not against the individual innocent owner.
And there was a judgment lien, but it was...
Yes, but it was
discharged.
extinguished by the foreclosure.
Do you have
That's the
anything
wrinkle.
do you have anything to say about the fee issue and whether if we disagree with you and they can enforce the judgment, should it include fees and should it include post-judgment collection fee?
Well, I believe that as much as I don't like it, I believe that the attorney's fees were part of the initial underlying judgment. They're there.
So that's the pre-judgment fee, but what about the collection?
No, the judgment, the fees for the trial and for,
Okay.
getting to judgment. To be honest with you, I'm not as familiar with the Condo statute. I would normally say that the costs of collection are not included in this and should not be part of the judgment. Under our judgment statutes, post-judgment interest, things like that. But I don't believe the costs of collection are in any way involved here.
Unless there's something in the statute.
Yes, and I'll be honest with you, I don't know, I don't have the answer to that.
That's what I understood you to say.
Yeah,
Yes.
yes.
Your premise is that the lien statute allows the court to look beyond the dollar amount of the judgment. Where do you get that?
I don't think the lien statute allows any of that. I think it's all about what the underlying judgment prescribed. The underlying judgment,
Well, it refers to a judgment for money,
yes.
and you're suggesting that the lien statute allows the court to look at the findings that were included in the judgment beyond the dollar amount. But I don't see anything like that in the lien statute.
It's not in the statute because
But where does the
analysis
court-
is at the underlying judgment level. The judge has the equitable power, I believe, to limit the enforcement.
So then what I really hear you saying is, and maybe I'm misunderstanding, it seems like you're agreeing that there was a claim stated. And this is really, because we're here on a motion to dismiss, and that there really was a claim stated, but for equitable reasons, which is based on the underlying judgment, this judge has decided that in this case,
No, I
they
don't.
should be precluded
I
from
think the
doing it.
equitable power to craft a judgment, a limited judgment, exists before the judgment lien statute comes into action.
Assuming that's the case, assuming without deciding that the judge has equitable powers, don't your client need to invoke court's equitable powers in some way? I mean, how does the court apply equitable powers to deciding a facially valid judgment lien claim, which this appears to
In
be?
this case, we have the nice situation where the intent of the trial judge is very clear to the judge in the second action. It's the same person.
So,
He knew
so are
what he
you
wanted
saying
to do.
the judgment wasn't a judgment for money against the association?
It was, but it was limited and restricted so as not to be lienable or assessable against the other unit.
But there's nothing in the statute. The statute just says a judgment for money against the association is a lien.
I believe the judgment lien has to follow the judgment, and if the judgment was crafted in a limited way, that in fact limits the effect of the judgment lien statute. Otherwise, we have a mechanical and absurd result. You know, why would the judge limit assessment only to allow the liens to take away the unit owner's property? It's the same thing. The result brings you to the same
Well,
place.
it sounds like what you were saying a little earlier was that nobody was contemplating this at the time the judgment was entered, that nobody thought that they were going to have to go after the unit holders. And that's why the judgment isn't more specific,
The judgment speaks only to assessments being prohibited.
because nobody thought that it would come to this.
Right, but if the judge had the equitable power approved by this court in the first case to make that limitation on the statute for assessment, it should have the same power to limit the use of the judgment lien
But if
statute.
nobody thought that it would come to this, then how can we construe the judgment as having the intent to do this if it did come to this?
Well, I think the intent is clear, and the clarification offered by the trial judge in the second action reinforces that. I think that if anybody had the thought to say, what about these liens, he probably would have made some statement regarding it in his underlying judgment. But what he did below was approved by this court and affirmed, with the exception of the unfair trade and the specific performance issues. So you've already affirmed that judge's power to use his equitable powers to limit and restrict a statute that otherwise says the condo association must assess against unit owners owning at the time of the judgment. That also was a monetary obligation, and the judge revised it or restricted it. I think it's the same issue with this statute, because to say otherwise would result in a really absurd result, completely in opposition to the equities of this case.
Why is it so absurd? And why is it so unfair if as the attorney, as your counsel, brethren has said, you bought these after you knew what was going on, and it probably affected the purchase price?
Well, that's not an evidence what the purchase price was affected by, first of all.
But if we're going to look at equities,
My
wouldn't we
client
be looking at that?
My client bought 4 units from the innocent unit owners. 4 of them were purchased. 15 were taken at foreclosure, and 4 more were purchased, and there remain 3 unit owners that are still privately owned, in addition to his 2 clients. Actually, one of the ones my client bought was one of the appellant's units. Okay? Ms. Brown sold her unit to my client. So I'm not sure how to answer your question, but that the fact that they were aware of it, they made a judgment that it was not a valid claim and proceeded.
Well, if this is an attack on the fairness of the statute, everybody needs to understand what the statute says. And doesn't the statute, as you, in your answer to the chief, as a general rule, this is the result, right? The result is innocent unit holders have to pay a proportional amount.
But in those cases, in almost all of the way the statute was, I think the reason for the statute is most of the times associations are sued, it's either for failure to pay for goods, the benefit of which was received by unit owners, all of them, or negligence, in which a unit owner is running a valid association should be responsible for any negligence that the association is guilty of. In those cases, that makes sense. It's fair, because the unit owners benefited from the unpaid contract, or they had some involvement or responsibility for the breach of a duty. But this is none of those things. This is completely different nature of a claim, and it's unusual, which is why the judge said equitably, I can't allow this to go in the normal course. Otherwise...
But didn't the plaintiff unit holders have to carry the water in pursuing this claim? And so it's basically free riding.
Yeah, but that has nothing to do with whether they should pay. Whether or not they did or didn't choose to join with the other plaintiffs to be plaintiffs doesn't in any way require them now to have to pay. They were just victimized the same way the two plaintiffs were. All of them were. None of them had any benefit from any of this. Just so the fact that they didn't have the money or the desire to be plaintiffs shouldn't be held against them when it comes to who has to pay for this. That's a wrong reason, I think.
So if one unit holder pursues the claim, they don't get any relief?
No, they should get relief, but it depends on what the claim is. And this is a claim in which the other unit owners, non-parties, were not alleged to have done anything. There was no evidence adduced that they had been responsible for any of it, they had any benefit from any of it, nothing. So in this case, it's unlike the normal use of that lien statute. The judgment against an association usually means there's some benefit to all the unit owners that didn't get paid for. And that's why this case is different. That's not the case here.
But that's not expressly set forth in the statute.
No, it is not. It is not. It's the equitable powers of the trial court. And in the exercising of those equitable powers as to the assessment statute, this court affirmed it. I don't see why the lien statute should be treated any differently than the assessment statute. And I think the equitable power is there. It was exercised, and it was clearly intended by the trial court. There's no uncertainty here at all.
There don't appear to be additional questions. Thank you.
Thank you for your time.
And Mr. Reilly, you reserve 3 minutes for rebuttal, I believe.
Thank you. Just a couple quick points. The enforceability of the underlying judgment wasn't before the lower court at the time of the underlying judgment. The other unit owners weren't parties to the case because we didn't have claims against them at that point. We had a claim against the developer and the association. The enforceability of the underlying judgment became an issue after we got the underlying judgment. And then we sought to enforce it. That's when those issues were joined. So they weren't there as an underlying matter. To give one example of why this is an unusual case solely in the fact that it involves a condominium association, not a judgment against an LLC or against an individual. It involves a condominium association that can only raise money. A judgment against the association has merit only if the association can pay that judgment by getting money from the members of its association. That's it.
And you're saying that essentially, if that were not the case, a judgment against the condo association would be entirely meaningless because it's never going to have assets aside from its ability to raise money from the condo owners.
Absolutely. And we would say, I would make 2 very quick points. On the other, there was no benefit conferred. First off, as Justice Lawrence pointed out, that's not in the statute. But secondly, there absolutely was a benefit conferred. This association, as was documented in the underlying judgment, was completely non-functional. The unit owners were marooned inside of it. Nobody could do anything. My clients changed that for everybody. Second point, it is not the case that claims against, that this statutory lien would exist only for, say, a lawn mowing service that sued an association to get paid for that. I'll give an example. Association member discriminated against by the other members of the association, sues the association, wins the judgment against the association. What do they do? How do they enforce that if the underlying judgment is the law? Because they are a member of the association. Arguably, under the theory of the appellees, what benefit did the other association members get from that? But there is a judgment for money by a unit owner against the association. That is a statutory lien by its clear and plain terms.
Thank you.
Thank you very much.
Thank you, counsel. As is our usual practice, we'll be taking the matter under advisement and issuing a written decision in due course. With that, we'll be in recess on this matter.